An interesting limit on rulemaking power. In perusing some of the statutes in California's 29 codes, and with a keen interest in administrative law and the rulemaking process, I came across an interesting provision in state law recently. It's Fish and Game Code Section 6885. It states that the Fish and Game Commission has, quote, no power to modify the provisions of this article by any order, rule, or regulation. What does this statutory provision is so interesting? Executive branch agencies, departments, boards, commissions, and bureaus can engage in what we call quasi-legislative activity, that is rulemaking. And that's generally through a statutory grant of lawmaking authority that obviously comes from the enactment of a statute by the legislature, who, as you know, is granted lawmaking power by the state constitution and signed into law by the governor, who essentially oversees the executive branch bureaucracy. However, in this particular case in the Fish and Game Code, the legislature enacted a statutory provision prohibiting a state commission in the executive branch from enacting any order, rule, or regulation that would be used to implement or interpret an entire statutory scheme. Remember, it refers to the article contained within this code. As a result, this particular commission doesn't have rulemaking authority in regards to these provisions of the California Fish and Game Code. Now, the legislature, in my mind, might want to consider similar statutory limitations on certain executive branch entities and their rulemaking power, of course, when it deems that to be an appropriate cause. There is a precedent for doing so, obviously, here in the California Fish and Game Code, and I think these limitations are much better than a number of statutory exemptions from the Administrative Procedure Act, the APA, that have been created by the legislature each and every year.